On December 19, 2026, Clint Keeler was arrested in Cadillac, Michigan after police stopped him on Pollister Road and discovered he was operating a vehicle with a blood alcohol content of 0.183, more than double the legal limit. What began as a potential felony charge of operating while intoxicated third offense was resolved through plea negotiations in the 46th Circuit Court for Wexford County, where Keeler appeared before the judge to enter a guilty plea to a reduced charge and face the consequences of his second drunk driving conviction.
Well, let's go ahead and take care of Clint Keeler. Get this guy, this counsel out of here. When I say out of here, we're not trying to force him out. We're just trying to let him know that. All right. So this case number is 26-14184-FH. Appearances, please.
Joanna Garrett for the people.
Thank you. All may be seated. Mr. Keeler is here next to counsel. All right, I see Mr. Keeler is from Hibma Road. That's the one road that seems to cross and you pop up against it all over the place. Although it stops for a mile, continues for another mile, stops. Anyways, all right, so I'm giving it all enough time to talk about and tell them what's going on, but I'm told here that we intend to, the parties intend to enter a plea. This, Gary, why don't you go ahead and tell me what it is?
My understanding, the defendant's going to plead guilty to added count 2 operating while intoxicated. Second offense, the people will dismiss offense notice, and it's my understanding that at least I do not have a substance use.
Yeah, please sheet and then advice of rights would be great, gentlemen. Counsel, you may. And I don't know if you did this actually intentionally, sir, but you are wearing Hope College colors, so that's a point in your favor. Okay. Thank you very much. But not a big. Mr. Shuey, is that correct and accurate statement?
That is my understanding, Your Honor, and that is true. We have not had an assessment yet. I wasn't quite certain.
No,
I was going to ask for a pre-sentence investigation.
I will. All right, Mr. Keeler, have you heard what the attorneys have told me we're going to do today?
Yes.
Is that how you wish to resolve the case?
Yes.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
You may lower your hand.
The judge began the plea hearing by confirming the negotiated agreement between the prosecution and defense. Keeler would plead guilty to operating while intoxicated second offense, a misdemeanor, in exchange for dismissal of the original felony charge of third offense OWI under Section 257.625 of the Michigan Vehicle Code. Operating while intoxicated becomes progressively more serious with each prior conviction. A first offense is a misdemeanor punishable by up to 93 days. A second offense elevates penalties to up to 1 year in jail, and a third offense within a lifetime transforms the charge into a felony carrying 1 to 5 years in prison. This statutory scheme, often called a stepped penalty or habitual offender structure, reflects legislative intent to treat repeat drunk driving as an increasingly severe public safety threat. The prosecutor's discretion to reduce charges through plea bargaining is governed by Michigan Court Rule 630-02, which requires court approval of any agreement and ensures the defendant understands its terms. Here, Keeler faced a felony carrying potential prison time, but through negotiation, the parties reached a resolution limiting his exposure to misdemeanor penalties. The judge's methodical confirmation of this agreement, questioning both attorneys and the defendant, fulfills the procedural safeguards of Rule 6302, ensuring the plea rests on a valid factual and legal foundation rather than coercion or misunderstanding. Plea bargaining resolves approximately 90% of criminal cases nationwide, making understanding its mechanics essential to grasping how justice actually functions. The charge reduction here from felony to misdemeanor demonstrates how prosecutors can tailor outcomes to case-specific factors like defendant cooperation, evidentiary strength, or mitigating circumstances, while still holding repeat offenders accountable through enhanced misdemeanor penalties.
Mr. Keeler, looking back on December 19th of 2025, were you on probation or parole?
No, Your Honor.
Were you on bond pending any felony charges at that time?
No, Your Honor.
All right, thank you. You are currently charged on a piece of paper called a felony information with a single count. That count is operating the vehicle while intoxicated or impaired as a third offense. Now, initially, an operating while intoxicated is a misdemeanor punishable by up to 93 days and or a minimum of 100 up to a maximum of $500 and or 360 hours of community service plus other costs for rehabilitation, prosecution, and mandatory vehicle mobilization. However, because it's charged as a third, that increases that from being a misdemeanor to a felony, and the maximum punishment up to a minimum of $500 to a maximum of $5,000 in fines plus costs. And then either a choice of, which is given by the court, a minimum of 1 year to a maximum of 5 years in prison, or the alternative to a prison sentence, a period of probation, and a mandatory minimum of 30 days to a maximum of 1 year in jail. Plus, again, costs for prosecution, costs for emergency responses, costs for rehabilitative programming, vehicle immobilization of at least 1 year and up to 3 years. However, I'm told that count one will be dismissed if you enter a plea of guilty to, and I accept that plea, and added count two. Added count two would be a lesser version, it'd be the one right in between what I've talked about. I gave you what the maximum punishments were for just a simple drinking and driving. And then I told you what they were for what you're charged, which is the drinking and driving third. You're going to plead to a drinking and driving second. That is a misdemeanor punishable by up to 1 year and or up to $1,000. Plus there would be cost for rehabilitative programming, cost for prosecution, cost for any emergency responses by law enforcement, and also vehicle immobilization would be mandatory. You understand?
Yes, Your Honor.
All right, now this, by the way, is what I see contained here on this written pretrial agreement. And it appears to have your signature. I'm holding it up. Is that your signature?
Yes, Your Honor.
Now, did you talk about all this with the counsel?
Yes, Your Honor.
Was he able to answer all your questions?
Yes, Your Honor.
And are you satisfied with his advice and representation?
Yes, Your Honor.
The judge conducted the plea colloquy, a constitutionally mandated questioning of the defendant to establish that his guilty plea is knowing, voluntary, and intelligent by explaining the original felony charge, the reduced misdemeanor charge, and confirming Keeler's understanding and satisfaction with his attorney. The Supreme Court established in Boykin, Alabama, 1969, that due process requires trial judges to personally ensure defendants understand they are waiving three fundamental constitutional rights: the privilege against self-incrimination, the right to trial by jury, and the right to confront one's accusers. This requirement was reinforced in Brady v. United States, 1970, which held that guilty pleas must be voluntary in the sense that they are not the product of actual or threatened physical harm or mental coercion overbearing the will of the defendant. Michigan Court Rule 6302 EPBB operationalizes these constitutional mandates by requiring judges to determine that the defendant understands the nature of the charge and the maximum possible sentence, and that the plea is voluntary and not the result of force, threats, or promises, other than those in the plea agreement. The judge's detailed explanation of the charge reduction from third offense felony 1 to 5 years prison to second offense misdemeanor up to 1 year jail directly satisfies Rule 6302B's requirement that defendants understand the maximum possible sentence. His sequential questions about counsel consultation, question answering, and satisfaction with representation build a record demonstrating the plea was not the product of force, threats, or promises beyond the disclosed agreement. Without this judicial verification, defendants could later claim their plea was coerced or misunderstood, undermining finality and potentially requiring costly post-conviction litigation. The colloquy protects both the defendant's autonomy interests and the state's interest in reliable, appeal-proof convictions. For viewers, this exchange illustrates how constitutional rights are not abstract concepts, but procedural checkpoints actively enforced in every plea hearing.
And you believe so far taking this plea is in your best interest?
Yes, Your Honor.
Thank you. Now, if you enter a plea of guilty, and I accept that plea, you'll be waiving certain rights, not have a trial. Does that make sense?
Yes, Your Honor.
Now, I'm holding up a form that your counsel also gave to me, and at the top it says advice of rights, at the bottom has your signature. Is that your signature?
Yes, Your Honor.
Did you read through these rights before signing?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And even more importantly, do you understand that if you plead guilty and I accept that plea as we discussed, you will be forever waiving these rights as they apply to this particular case?
Yes, Your Honor.
Also, you'll be given up the right to claim that the plea was the result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, inducements?
No, Your Honor.
Are you entering the plea of your own free choice?
Yes, Your Honor.
Now, Mr. Sui's probably talked to you about potential sentencing. Now that it would be a misdemeanor, not a felony, the sentencing guidelines don't apply. He's probably tried to give you an idea or an estimate as to what he thinks the court may sentence you to. Has he or anyone promised you exactly what the sentence would be from this court?
No, Your Honor.
Knowing all that, do you still wish to enter the plea of guilty as we discussed earlier on the record?
Yes, Your Honor.
As to the added count 2 of operating while intoxicated as a second offense, how do you plead, sir?
Guilty.
The judge continued the colloquy by confirming Keeler understood he was waiving constitutional trial rights, had read and understood the written advice of rights form, and was entering his plea freely without undisclosed promises, specifically including that no one had guaranteed a particular sentence. The prohibition on judicial sentence promises during plea negotiations reflects the principle established in United States v. Benchamal, 1985, where the Supreme Court held that while judges may approve or reject plea agreements, they should not participate in negotiations to avoid creating appearance of coercion. Michigan Court Rule 6302, C3, explicitly requires the court to inform the defendant that the court is not bound by the plea agreement and that the defendant cannot withdraw the plea if the court does not follow the plea agreement. This rule prevents defendants from claiming detrimental reliance on anticipated sentences. When the judge asks whether he or anyone promised you exactly what the sentence would be, he enforces Rule 6302C3's requirement that defendants understand judicial independence in sentencing. Keeler's no response, combined with his continued desire to plead guilty, creates a record showing his plea rests on acceptance of potential judicial discretion rather than fixed expectations, a critical protection against later claims of unfulfilled promises. Sentence uncertainty is the price defendants pay for charge reduction through plea bargaining. This exchange teaches viewers that guilty pleas involve calculated risk. Defendants gain certainty about their conviction status, but surrender control over punishment severity. The judicial refusal to bind sentencing maintains the court's role as independent arbiter rather than negotiation participant, preserving public confidence in sentencing fairness.
Before the court can accept that plea, I need you to tell me what it is that happened on or about December 19th here in the city of Cadillac in Westford County. Were you operating a vehicle?
Yes, Your Honor.
And it looks like it was in a highway or a roadway open to the public. Is that correct?
Correct, Your Honor.
And it looks like it is over on Paulister, which is on the south end of Cadillac, just before you go up the big cemetery hill, right?
Yes, Your Honor.
And were you pulled over by a police officer?
Yes, Your Honor.
And prior to that, had you been consuming alcohol?
Yes, Your Honor.
And again, you were operating the vehicle?
Yes, Your Honor.
Ms. Carey, does the prosecution have a blood alcohol?
There was a
Number?
blood draw. The result was 0.183.
Mr. Sui, does the defense stipulate for the acceptance of the plea and the sentence?
I do, Your Honor.
All right. Ms. Carey, do you believe the defense provided a factual basis in addition to the acceptance of that blood alcohol test?
I do.
Oh, hold on. I'll cover the second element in just a second. Are you aware of any other promises, threats, or inducements?
Not.
Maybe the court's compliance with Scroll 6.302.
Yes.
Mr. Sui, how about you? Do you agree with all that?
I do, Your Honor.
So, Mr. Keeler, what I forgot to ask you is one other question, and that is about the second the second offense. So I will pick the last one that I see listed here. And is it true that on or about August 5th of 2004 in the 56th A District Court down in Eaton County, you were convicted of operating while intoxicated?
Yes, Your Honor.
All right. The court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record satisfies the elements for the added count 2. Therefore, the defendant is found guilty of operating while intoxicated as the second offense. The higher offense, the felony, will be dismissed at the time of.
The judge required Keeler to provide a factual basis for his plea by admitting to operating a vehicle on a public road while intoxicated, with the prosecution confirming a blood alcohol content of 0.183, well above Michigan's 0.08 legal limit, before accepting the guilty plea and entering judgment. Michigan Court Rule 6302D mandates that courts shall not accept a plea of guilty or nolo contendere without first determining that there is a factual basis for the plea. This requirement, tracing to common law pleading standards and reinforced in McCarthy v. United States, 1969, ensures that defendants cannot plead guilty to crimes they did not actually commit, protecting both innocent defendants from coerced convictions and the integrity of judicial proceedings. For operating while intoxicated under Section 257.615, 1A, the elements require proof that the defendant operated a motor vehicle upon a highway or other place open to the general public while under the influence of alcohol. Keeler's admissions operating a vehicle on Pollister Road, a public roadway, after consuming alcohol with a 0.183 Beck, collectively satisfy every element of second offense OWI. The judge's methodical questioning about location, highway or roadway open to the public, directly addresses the jurisdictional element, while the prosecutor's blood test stipulation provides scientific corroboration exceeding the statutory per se intoxication standard of 0.08 grams per 100 milliliters under Section 257.625 1B. The factual basis requirement serves as a final checkpoint against false convictions, ensuring that even consensual guilty pleas rest on actual criminal conduct rather than convenience or coercion. For educational purposes, this exchange demonstrates how scientific evidence, blood testing, intersects with defendant admissions to prove guilt beyond reasonable doubt, a standard that, while technically waived by guilty plea, must still be supportable by the record.
Sentencing. So what we do here is, even though it's a misdemeanor, I still have a pre-sentence investigation report prepared. One of these reports must be prepared when someone's convicted of a felony in a state court of Michigan, but I also will have them prepared when I'm considering a period of probation, which may be appropriate. Therefore, when you leave this courtroom, you're going to go downstairs to the bottom floor, which is also called the ground floor. You take the elevator or the steps, they end up in the same place. All the way down to that ground floor, do a button hook to the right. At the end of that hallway, there'll be a door. Go through the door. Now, if you know where community corrections is at,
Yes, Your Honor.
if you were to stand right in front of their office, do an about face and take 3 steps forward, you'd be right where you need to be. They're going to give you a packet. You're going to complete that packet, turn it in. They will schedule an interview with you. You have the right to have your counsel present during that interview. They will also issue this report generally about 10 days, maybe 2 weeks prior to our sentencing date. We do sentencings in this court every Monday morning. That report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide, as well as information about any prior criminal history you have, performance on bond, performance on probation, and or I didn't see a fourth habitual enhancement, so there's no parole issues. We'll also make a recommendation of sentence. Please keep in mind it's merely a recommendation. If you're getting any kind of treatment or seeking that out on your own, or if I gave you any or the courts gave you any enhanced outpatient treatment programming through corrections, I encourage you either to pursue it or keep pursuing it. Either way, those things will go a long way with me. Mr. Sui, any questions, anything further?
Your Honor, I do have one request
Okay,
made on behalf of.
Ms. Carey, any objection to the time concerns?
No,
Go ahead, sir.
Your Honor, Mr. Keeler has full custody of his 17-year-old daughter, and they had planned April 27th to April 5th to Savannah, Georgia, before it is actually, obviously he understands he cannot leave without permission from this court.
Ms. Carey, any objection to allowing a bond modification to permit him to travel out of the state?
I was just going to say that he's been doing AA, he's been doing everything that bond has been asked to do, and he's been tested negative.
I would have said.
Did you go to the Garden of Good and Evil? It's a book.
I have, Your Honor.
All right. And Johnny Mercer's from there? Or we still play there? Yeah. But anyways, I'm sorry, I digress. All right, the court will modify the bond to allow the defendant to leave between those dates, leave the state of Michigan, to travel to and from Savannah, Georgia. His bond condition of he still can't possess or use alcohol and will be subject.
Clint Keeler's guilty plea to operating while intoxicated second offense was accepted by the court, with the original felony charge of third offense OWI scheduled for dismissal at sentencing. The court ordered a pre-sentence investigation report to be completed by Community Corrections, with sentencing set for a future Monday morning session. Keeler's bond was modified to permit travel to Savannah, Georgia on March 27, 2026, to take his 17-year-old daughter on a planned trip, subject to continued alcohol abstinence, random testing, and prior notification of any travel changes. The defendant faces up to 1 year in jail and/or $1,000 in fines plus costs, though the judge indicated probation with rehabilitative programming remains a possibility depending on the pre-sentence report and Keeler's continued compliance. This case illustrates the machinery of American criminal justice as it actually operates, not through dramatic trials, but through negotiated resolutions that balance efficiency, proportionality, and defendant autonomy. The plea bargaining system constitutionally validated in Bordenkircher v. Hayes, 1978, where the Supreme Court held that prosecutors may threaten greater charges to induce guilty pleas, channels the vast majority of criminal cases away from trial while still requiring judicial oversight to protect defendants from unknowing or coerced waivers. Several interconnected principles emerge from Keeler's hearing. First, the knowing and voluntary requirement represents due process in action. The Constitution does not prohibit defendants from surrendering rights, but demands they do so with eyes open. The elaborate colloquy, questioning about counsel consultation, rights comprehension, factual admissions, and sentence expectations, builds a record that can withstand appellate scrutiny and collateral attack. Second, the stepped penalty structure for repeat drunk driving reflects a legislative judgment that culpability increases with persistence. By reducing Keeler's charge from third to second offense, the prosecutor acknowledged mitigating factors, compliance with bond conditions, family responsibilities, treatment engagement, while preserving enhanced penalties unavailable to first offenders. This discretionary charging power, while subject to potential abuse, allows individualized justice unavailable in rigid mandatory sentencing schemes. Third, the pre-sentence investigation process demonstrates how misdemeanor and felony procedures increasingly converge for serious offenses. Though no longer facing prison, Keeler will undergo the same evaluative scrutiny: criminal history, substance abuse assessment, employment verification, victim impact, that felony defendants receive, enabling data-driven sentencing rather than intuitive guesswork. Finally, the bond modification for family travel reveals how courts can balance public safety with human needs. The judge's practical advice, locating testing facilities in advance, maintaining communication with supervision officers, models problem-solving justice that recognizes defendants as people with legitimate obligations, not merely cases to be processed. This approach, consistent with the risk-need responsivity principles of effective correctional intervention, may ultimately better serve rehabilitation than rigid prohibition. For viewers, Keeler's case demonstrates that criminal court is neither the adversarial combat of television drama nor bureaucratic indifference, but a complex institution negotiating competing values: efficiency and accuracy, punishment and rehabilitation, individual rights and collective security. Understanding these tensions is essential to informed citizenship in a society that incarcerates more people than any other democracy while simultaneously professing commitment to liberty and due process. If you found this case illuminating, subscribe for more educational court content that demystifies legal procedure. Share this video with anyone interested in criminal justice, law school preparation, or understanding how courts actually function. Comment below with questions about plea bargaining, DUI law, or sentencing procedures. Your engagement helps us develop future content addressing viewer interests. And remember, the procedures you've seen here protect constitutional rights daily in courtrooms nationwide, making their understanding vital for every citizen.